Yeah, that ruling just out this morning, and we've been parsing through it, trying to figure out exactly that. What does this mean for all these tariffs that Donald Trump has imposed, not just on other countries, but also on Canada and our trading partner, Mexico? The decision from the Supreme Court today is with respect to something called the International Emergency Economic Powers Act, IEEPA or IEPA. It is not applying to some of these sectoral tariffs that Trump has imposed on Canada, but it does capture the fentanyl tariffs that he imposed initially, as well as the Liberation Day tariffs on other countries. So we're talking about those fentanyl tariffs on Canada, Mexico, and China. You remember that this was going to be initially a 25% tariff on all products from Canada entering the United States because Trump was concerned we weren't doing enough to stop the flow of illegal migrants, as well as the flow of fentanyl and some of the precursor drugs for that. And then there was the Liberation Day tariffs using the same economic powers under that act to impose tariffs on all other countries. The thing about the tariffs on Canada, though, is that we were given exemption to any goods that are traded under the existing Canada, U.S., Mexico trade agreement, the CUSMA, as we call it here. The Americans call it USMCA. So it's important, this decision, but it doesn't totally change things for Canada. But it is a real rebuke to Donald Trump because this was a 6-3 decision of the court with 3 conservative judges on the majority side. And they are saying that Donald Trump essentially overrode the requirements to impose these emergency tariffs. And they write in the decision, in light of the breadth, history, and constitutional context of that asserted authority, meaning the authority under IEPA to impose those tariffs, he, being Donald Trump, must identify clear congressional authorization to exercise it. They say the emergency authority that Trump has attempted to rely on does not effectively fall short of that standard. So in short, what the court is saying is that Donald Trump should have gone to Congress before he imposed these tariffs on Canada, Mexico, and the rest of the world. But it is silent on the so-called Section 232 tariffs. Those are the ones that Trump used. He initially used it back during his first term in 2018 to go after Canadian steel and aluminum. He's done it again with the 50% tariff on steel, aluminum, also additional tariffs in the auto sector and softwood lumber while this CUSMA review process is ongoing. So those tariffs will stand, but overall, I think it's a good sign for Canada and our trade dispute with the United States because for the first time, the Supreme Court is pushing back against Trump on this sort of signature economic policy of his. It's a real rebuke to him. He will not be happy. He will be upset about this. He has, though, anticipated this, and members of his administration have talked about if the Supreme Court were to do this, to set aside the IEPA tariffs, they would find other ways to put those tariffs into place, like potentially the same Section 232 tariffs, although that could also trigger another appeal to the Supreme Court, another review of this in the judicial system, but that will take weeks and months, through which time we will already be engaged in that review of the CUSMA decision. So big news for Canada, good news for Canada, but it does not mean yet, FISA, that we are out of the woods yet on these tariffs that have been so destructive to our economy.